And we come to the powers of the court for winding up. After making up the winding order from section 251 to 269, the court has the power to stay winding up proceedings. At its discretion, it may stay the order that you may have wanted to wind up, but the court looks at the case-by-case basis and decides that let other parties be heard. If, for instance, the members wanted a chance to fight for this company, we said why there's voluntary winding up. You have seen that in the near future, there's no hope of you making any profit. And you pass a resolution, then the court may decide, what if the members want a chance to make it work again? It may stay the winding up proceedings, and this means they'll not proceed. The winding up will not be done until, again, the court decides, no, we have heard what you had in mind. Your ideas may not be viable. They may prolong these transactions. So let us just forget about the ideas and continue with that. The court also has the power to settle a list of contributories and order for the realization of the company's assets. This is where the assets will be collected and realized. So they pay off the debts, they pay off the contributories. Each person gets an amount equivalent to what the court will declare. The court has the power to order for the delivery of the property to the liquidator. These are books of accounts, anything that the liquidator may need to make decisions regarding the company. And in books of accounts, ownership documents as well, the registers that we mentioned that must be kept. And the court also has the power to make calls. And this is where it finds it, there's a deficiency of assets to meet the company's liabilities and the expenses of winding up. It will call unto them to pay up any unpaid share capital so that the company is able to settle its debts. And the court also has the power to exclude any creditor that did not prove their debts in time. We say that it's up to the creditors to prove their debt. And because they're normally given a notice, if they extend the period in which they were given, the court has the discretion to not allow their debt to be considered in the list of creditors. So the court will order anyone that they suspect has the company's property or whom they may deem, auditors may be ordered to come and provide the correct information regarding to the status of the company. So the court may order anyone to come and actually be present to make these proceedings work to the best of the company's interests. The court on winding up will order a public examination of the promoters, of the directors, of any other person who may be involved in the day-to-day. And this is where there's that, the official liquidator reports fraud has been committed during the formation or promotion of the company, or any director in the office of the company is involved with any fraud. So the court may order the person to appear on it, before it, to answer to these issues of fraud. Once the court is satisfied that the debts have been paid off, the deductions have been made, statutory deductions have been paid, employees have been paid, then it orders the dissolution of the company. And within 14 days, the liquidator shall file a copy of the order with the registrar. And that time will be marked when it happened. The court also has the power to declare a dissolution void. Within 2 years of the date of dissolution, and this is the Court of Appeal now, it may discover that this dissolution was invalid and therefore will set it aside.